The third institution of government that we'll look at is going to be the federal court system. And the federal court system is going to be established by the Constitution in Article 3. It establishes the federal judiciary, but the only court specifically mentioned in the Constitution is the Supreme Court. And the Constitution and the Founding Fathers gives Congress the power to create all other federal courts. So the only court that the founders provided for was a Supreme Court, and it delegated the power to create all other federal courts to Congress. So there's one constitutional court, and then all the other are federal statutory courts. The judiciary's role in government is essentially to just settle disputes. It's kind of like the referee of government. Their job is to look at cases, essentially, settle disputes between people, between governments, between the people and the government, between states and the federal government. And so there's going to be a bunch of different ways in which the court can play into the lives of individual citizens. And so there are two different types of cases that are tried. There are criminal law cases, and these deal with disputes or actions involving criminal penalties. In these cases, the government will charge an individual for violating a statute, for violating a law. And in these cases, you will have a plaintiff, and the plaintiff is the individual or organization that brings the complaint to court. In criminal law cases, this is always the government. So you've probably heard the state of Texas versus such and such in a murder trial or something of that nature. That would be a state example, but the federal court, the federal court versus such and such would be more of a federal case, and we are talking about federal here. But there's also the defendant, and the defendant is the one against whom a complaint is brought in a criminal or civil case. Criminal law cases, the individual, in criminal law cases, it's going to be the individual or the organization that the government is bringing charges against. And so criminal law includes anything from traffic violations to robbery to murder, those types of things. Now, civil law cases are the other type of cases that are tried, and these deal with disputes among individuals or between individuals and the government. But they do not involve a criminal penalty. In a criminal law case, those things are going to be settled usually with, if it's a guilty verdict, then somebody's going to have served some time or be fined something. There's going to be a criminal penalty. But there are civil law cases. There aren't necessarily going to be criminal penalties. And the two most common types of criminal law cases are contract cases, so violating an agreement, and torts. And torts are when one individual charges he has been injured by another's negligence or malfeasance, so typically medical cases. So two different types of cases: criminal law cases and civil law cases. And before we get too in-depth in the federal judiciary, I'd like to go over some important terminology. Now, these things will pop up as we talk about the federal judiciary more and more. But the first couple of terms, plaintiff and defendant, we've already discussed those. But then there's a term called precedent. And precedent means prior cases whose principles are used by judges as the basis for their decisions in present cases. So when deciding cases, courts will apply both the statutes, the laws, they're going to apply the laws, but they will also look to precedent. What have other courts decided in cases similar to this? And they're going to base a lot of their decisions based upon precedent. Is there any precedent set? What has happened in the past? They want to try to be as fair and consistent across the board as possible. There's a lot of Latin terms in regards to the federal judiciary, and one of those is called stare decisis. And stare decisis is a Latin term translating roughly as, quote, let the decision stand. When there is a reliance on precedent regarding an issue, they will essentially utilize stare decisis. The Supreme Court says utilizing stare decisis, quote, promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. So if somebody brings this case before a federal court and it's already been decided in another case, they're not going to retry it and come up with a different decision than has already been decided. They are going to allow the decision to stand. They're going to look at that precedent that has been set by other cases, and that's what they're going to essentially go with. In the United States, we have two sets of courts. We have federal courts, which deal, obviously, as it sounds, at the federal level. And then we have state courts. Each individual state is going to have their own court system, and so they operate in tandem with one another. State courts enforce the laws and statutes of a particular state. Now, 97% of the cases that are heard are in state court, okay? And state courts have similar models and structures, and they're going to vary depending on the different state that you are in. But they've got trial courts, they've got appellate courts, and they have state supreme courts. We are dealing specifically with a federal court in this course because it is federal government. Now, some decisions that are decided at the state level, if they run their their gamut, they run their appeals all the way through the state Supreme Court, they can be appealed to the U.S. Supreme Court, but excuse me, it doesn't often happen. Okay, so we're going to be dealing with federal courts in here, and federal courts are any time that a federal statute, a treaty, or the Constitution is involved, the jurisdiction is in the federal court. And so that leads us to the term jurisdiction. Jurisdiction is the sphere of the court's power and authority. If you broke a speed limit law in the state of Texas, that's a state case. The federal government delegates to the states their ability to set, safety precautions and things like that. That's a state thing. And so that is not federal jurisdiction. Federal jurisdiction is anytime you break a federal law. You murder somebody in the state of Texas, that's going to be a state case. However, if you transport that body across state lines, that becomes an interstate issue and it becomes federal. And so it's going to be tried at the federal level. And so the different courts are going to have different spheres of influence or spheres of jurisdiction. And then the writ of habeas corpus, and we mentioned the writ of habeas corpus when we talked about Abraham Lincoln under the presidency. And the writ of habeas corpus is a court order that the individual in custody be brought into court and shown the cause of his or her detention. So you cannot just be jailed for no reason. The government has to show you why you are being detained. And it has to be a legal reason as to why you are being detained. It cannot just be on a whim. And the Constitution says explicitly that the writ of habeas corpus cannot be suspended. But obviously it was suspended under President Abraham Lincoln. So these are just going to be some terms that we might come across as we move through talking about the judiciary. So let's look at the levels of federal court. Federal district courts. This is going to be the lowest level, and there are over 300,000 cases in federal district courts per year. There are 94 federal district courts in the United States. They are staffed by 678 district judges. District judges are assigned to district courts according to the workload. The busiest districts might have as many as 28 judges. Only one judge is assigned to each case, except where statutes provide for a 3-judge court to deal with a special issue. District courts create the official record of the case. And so the procedure will be that in a federal case, there must be a grand jury to hear evidence in order to indict. You must be indicted by a federal grand jury, meaning there must be a panel of individuals who examine the evidence that the prosecutors have against you, and they must vote to indict you. They either say, yes, there is enough evidence, we're going to issue an indictment, or no, there isn't, and we're going to throw out this case. Then you must have a 12-member jury trial by a jury of your peers, 12 individuals, and then you must have a unanimous jury verdict to convict. So that's sort of the procedure in a nutshell. Federal district courts usually have what is known as the original jurisdiction, and the original jurisdiction is the authority to initially consider a case. So this is the very basic level of the federal court. The federal district courts. There are lots of cases that are tried in the federal district court. There are lots of judges in the federal district court. There are 94 across the United States, and they typically are going to have original jurisdiction. Now, as we move up the ladder for the level of courts, you will start to realize that fewer and fewer cases are taken by these subsequently higher courts. And so the next level of court is going to be the appellate courts. The appellate courts have what is known as appellate jurisdiction. And appellate jurisdiction is to hear, is the ability to, or the authority to hear appeals from lower courts. Now, what you have to understand, they do not retry a case. No new evidence is taken. No new testimony is taken in an appeals case. The appellate courts simply review the case to ensure that proper procedure was followed. So if you feel like proper procedure was not followed, you can appeal your case to the appellate jurisdiction. If the appellate courts decide that proper procedure was not followed, they might review your case, and they might either uphold or reverse a lower court. 20% of lower court cases make it to the appeals level. They make it to the appellate court, and there are 13 total U.S. courts of appeals in the United States. And the way that this works is they divide up the nation geographically into 11 appellate jurisdictions. And then they have one appellate jurisdiction for D.C., and they have one for patents, trademarks, international claims, and claims against the federal government. Okay, and so it's obviously smaller. There are 13 federal appellate courts, and they are run by 179 judges, so significantly fewer judges than at the district court level. Oftentimes, when a case makes it to the appellate court, this is the final say. This is going to be the court of last resort. It's going to be a safeguard. There are going to be certain safeguards that are put into place because this is the case. This is the area that essentially will have the final say on a significant number of the court cases. And so some of the safeguards that are put into place at the appellate jurisdiction level is that more than one judge will review every appeals case. So whereas in the federal district court it's going to be one judge per case typically, in the appellate jurisdiction normally there's going to be a panel of 3, sometimes more cases that are going to review an appeals case. And so the idea is that 3 heads are better than 1, and having several sets of eyes looking at a case will ensure there are safeguards and that people are getting the fairest treatment possible. Each Supreme Court justice is assigned an appellate circuit to oversee. So they will actually be the overseers of these 13 appellate circuits. And so when they are not in session, they are said to be, quote, riding the circuit and overseeing their jurisdiction. The highest court in our land is the Supreme Court. And as we've discussed already, it is the only federal court established by the Constitution. And Article 3 says, quote, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. And so it's going to be the only court that is specifically mentioned in the Constitution. And it is made up of 9 justices. You've got 1 Chief Justice. The Chief Justice is going to be the individual that presides over the court's public sessions and conferences. They are going to be the individual that's the first to speak and the first to vote. But even though they are a little bit elevated than the other 8 justices, they still only get 1 vote. They have no higher voting power than everyone else. And depending on the chief, they can be very influential on the court. They can exercise a lot of power over maybe some other justices. And then we have 8 what are called associate justices. And associate justices are going to be the other individuals that are going to be deciders of cases that make it to the Supreme Court. The Constitution does not determine the number of justices. And in actuality, the number of Supreme Court justices has varied throughout history. In the early 19th century, there were only 6. It was later expanded to 7. In 1869, it was set at the current number of 9. And in 1937, Franklin Roosevelt is actually going to come up with what's known as the court packing scheme. So, as we know, Franklin Roosevelt in 1937, and during his early time as the president, is going to be engaged in what is called the New Deal. He's going to be instituting new programs and things like that. Well, the court kept striking down these New Deal programs as unconstitutional. And so this is going to anger FDR, and what he will do is he will ask Congress to expand the court so that he could appoint some new justices. Congress is going to say no. He wants to expand them, I think, to about 13 or 14 justices. Congress is going to say no, but the Supreme Court is going to end up sort of taking this as maybe the writing on the wall, understanding that the number can be changed, and they are going to give in and start viewing the New Deal programs more favorably. So even though it was kind of a political scheme, it worked, and in regard not because it made the Supreme Court larger, but it worked because it got the Supreme Court on the same page as the president. Now, all of the federal court justices are going to be appointed by the president and approved by the Senate. Presidents nominate all federal court judges, all of them. But the Supreme Court is the one that gets the media attention. These 9 individuals on the Supreme Court are going to be under a very watchful eye. Now, anytime a federal justice is appointed to the federal bench, they're appointed as a judge, they serve for life. Their term does not expire until they die, they resign, or in the case of impeachment. And so the Supreme Court, they have the ability to sort of step in and alter policies and things that are put into place by elected members of the legislature and the president. And so these appointed individuals, it might seem that they can affect policy very significantly, and they can, and they have, and they will in the future. And so they are put under an extreme microscope, and because there is no other court above them, and the only way to sort of supersede them is to change a specific law or pack the Supreme Court with more justices, as FDR tried to do, people are going to pay very close attention to who is appointed to the Supreme Court. And there are some interesting cases in the appointment and approval by the Senate. By and large, the Senate, they might rake a person over the coals, but by and large, they're going to be approved. It might be a close vote, but they will be approved. And so we're going to look at a couple of interesting cases. And the first one is an interesting case related to a man named Robert Bork. Robert Bork was a candidate for the Supreme Court. But he had, and he was nominated by Reagan in the 1980s. But he is best known for his role in Nixon's administration, and he is known as the henchman in what has become known as the Saturday Night Massacre. In the midst of the Watergate scandal, President Nixon is there's going to be a special counsel, and this might sound familiar because there has been a special counsel appointed to investigate some dealings of President Trump, and that was Robert Mueller. During the Nixon administration, there was a special counsel who was appointed to investigate the Watergate scandal. And Nixon decided that he wanted to fire that special counsel. And there's a lot of dispute as to whether or not they have the power to do that. Nixon orders the Attorney General to fire the special counsel investigating Watergate. This is one Saturday night. The Attorney General refuses and immediately resigns because he doesn't feel like that is within the power, purview, or scope of the president to be able to fire this special counsel who's been appointed. And so Nixon then goes down the line and he orders the Deputy Attorney General to fire the special counsel investigating Watergate. The Deputy AG also refuses and also resigns immediately. And so Nixon keeps going down the line, and he goes to the third highest ranking official in the Justice Department, who is known as the Solicitor General. The Solicitor General's office at this point was occupied by an individual named Robert Bork. And so he orders Robert Bork to fire the special counsel, and Robert Bork complies, and he does, and he fires the special counsel. So this becomes known as the Saturday Night Massacre. I don't think that the special counsel stayed gone long. I think the Congress reappointed him, like the following Monday. But it showed that Nixon was becoming very anxious about the investigation, and he knew some things were coming down the pipe. But this is in the 1970s. Fast forward to the Reagan administration. Reagan is going to nominate Bork for the Supreme Court. And there is a huge outcry against Robert Bork's nomination. There is a huge debacle regarding his approval by the Senate. And if you are nominated by the president, you have to go through the approval process, which means you are subjected to questioning, hours and hours and hours and hours and hours of questioning by the Judiciary Committee in the Senate, and then the full Senate has the ability to meet with you and decide whether or not they're going to vote on you. Well, Robert Bork is going to be voted out of the Judiciary Committee to a full vote in the Senate, but he will be defeated in the Senate by a vote of 42 to 58. And this is not common, especially during this time. Typically, if there's going to be somebody defeated, that person typically will withdraw their name, or the president will withdraw the nomination, or something of that nature. And so it was uncommon for this to occur, but Robert Bork is so controversial that he is defeated by the Senate. He is not approved. Clarence Thomas. In the presidency of George H.W. Bush, Clarence Thomas is going to be nominated. In the course of his nomination process, there is going to be an interest group investigations into his background that suggested that he had sexually harassed a former employee named Anita Hill. It's a very contentious judicial committee hearing. There's a lot of testimony between Thomas and Hill. It's very reminiscent of the Kavanaugh debacle that we'll talk about in just a minute, but the Kavanaugh Senate approval debacle that occurred recently when President Trump nominated Kavanaugh, and he had some women come out and say that he had sexually harassed them. Joe Biden, who was the vice president and is currently running for president for the Democratic nomination, was the chairman of the Judiciary Committee who oversaw the Clarence Thomas essentially judicial committee hearing that made these accusations against him and presided over the testimony, and he has still to this day receives a lot of criticism and backlash on how he handled that situation. But Clarence Thomas will narrowly win confirmation by the Senate vote of 52 to 48. Then there's Merrick Garland, and he was nominated by President Barack Obama, upon the death of Antonin Scalia, which left an opening on the Supreme Court. So what happens is this is during an election year. And even though it's in an election year, the president is supposed to be able to fill this seat. And so he nominates Garland, but the Republicans are in control of the Senate. And they absolutely refuse to take an action on Garland because it's an election year and they want to wait till after the election and they want the newly elected president to be the one to appoint the new Supreme Court justice. It's really not supposed to be that way. Whoever is the president at the time is supposed to fill that position, and the Senate is supposed to advise and consent. They should have just allowed the process to occur and then voted Merrick Garland, out and not approved him. But instead, they stonewalled and didn't allow for any action to be taken on Merrick Garland. So Merrick Garland will flounder in nomination for about a year. So they decide that whomever won the election should make the nomination, and it's a gamble because the Republicans are hoping that it won't be Barack Obama. It won't be Barack Obama, but they're hoping it won't be Hillary Clinton. And the gamble pays off because President Trump will win the election, and he will go on to nominate a more Republican, conservative individual in Neil Gorsuch. So Garland was sort of the Supreme Court justice who never was. And then there's the Brett Kavanaugh debacle. He was nominated by Trump, President Trump. He was pretty much raked over the coals. There were women who came out and said that he had sexually harassed them. They took testimony from these women, very reminiscent of the Clarence Thomas committee hearings. He will eventually be confirmed, and he is now on the Supreme Court. But the Supreme Court is supposed to be above the law, or above politics, not above the law, above politics, and it's not supposed to be a partisan thing. So why is it so partisan? It's partisan because the Supreme Court enjoys what is known as judicial review. And judicial review is the power to declare acts of the legislature and executive branch unconstitutional. They are the final word in regards to what is and what is not in line with the Constitution. And so they are going to have this power of judicial review. Now, this is not a constitutional power. This is actually a power that the court system gave themselves in 1803 with the case Marbury versus Madison. But it is a very significant power. Okay? And so they can declare acts unconstitutional, and they do, but people act like it's something that they do on a daily basis, and it's really not. It's not really done all that often. In the 200 plus years of our American history, only about 160 acts have been deemed unconstitutional. So they're sort of the referee. They sort of call it like they see it, but it isn't done on a daily basis. It's not something that they do all the time. So let's check our time. Okay, so I am going to go ahead and show you an image of the current Supreme Court. Then I'm going to stop this lecture, and I'm going to come back and we'll finish up the Supreme Court, or the judicial system, in our next part 2 of this lecture, and then we'll be moving on. But this is the current makeup of the Supreme Court in America. We have this individual's name is Neil Gorsuch. He was appointed by President Trump. This is Justice Sonia Sotomayor, the first Hispanic to be elected or appointed to the Supreme Court, appointed by excuse me, President Obama. This is Elena Kagan, also appointed by President Obama. This is Brett Kavanaugh, appointed by President Trump. This is Stephen Breyer. I cannot remember at this point exactly who appointed him. Could have been George H.W. Bush. Could have been Clinton. I don't remember. I'd have to actually look that up and get back to you. Clarence Thomas, appointed by George H.W. Bush. John Roberts, here in the center. He is the Chief Justice of the Supreme Court, and he was appointed by George W. Bush. This is Ruth Bader Ginsburg, who is a very, very, very popular figure, has a huge cult following, very liberal justice, has been on the Supreme Court since 1993, was appointed by President Clinton. And then this is Samuel Alito, who was appointed to the Supreme Court by George W. Bush. And so these people stay on the Supreme Court for a very long time. A lot of these people die on the Supreme Court. Justice Ginsburg is in her 80s. Justice Breyer, I believe, is in his late 70s, early 80s. So we're talking about people who stay on the Supreme Court and have the ability to affect policy long after the person who appointed them has left office. And so they have a whole lot of power that they can wield. And so we're going to stop here, and we'll pick up with the process of the Supreme Court in the next lecture.